Welcome to Discovering the Law. My name is Lucy Rivera and I am the host in this program. This episode can be viewed at www.discoveringthelaw.com. And today we have a very special guest and we're going to learn about the mysterious land court. Today we have Honorable Robert Foster, and he is here to talk to us about the land court, Your Honor. Thank you for being here today.
Well, thank you for having me, Lucy.
Judge Foster has been a judge in the land court for 3 years. He was in private practice for the past 10 years, and he was in the planning board of the town of Natick. Tell us a little bit about your background, Your Honor.
Well, I spent 18 years in practice in Boston after I graduated law school and clerked on the Supreme Judicial Court. My practice was at a firm in Boston, and I did real estate and land use litigation. And I appeared in the land court a lot for those cases.
And what is the land court?
So the land court is one of the 7 departments of the Massachusetts trial court.
Yes.
The different courts where you go in the first instance with a case and have a trial. There's Superior Court, District Court, Boston Municipal Court, Probate and Family Court, Juvenile Court, Housing Court, and Land Court. And as you can tell from the names, each of the courts have different areas that they cover. And by its name, you can tell that the land court concerns cases about land.
Yes.
Cases concerning real estate, title to real estate, and also cases concerning zoning and land use.
And why was the land court created?
Well, the land court was created back in 1898 when the legislature adopted a new system for keeping track of title to real estate. It's called a Torrens system, named after Robert Torrens, who was a judge or person in Australia who came up with this new system for keeping track of ownership of land. And it's called registered land. Now, it's a little hard to explain. Traditionally, and probably for most people who own their house who are watching this show, title to land was conveyed by giving a deed that is in writing and says, I, owner X, convey this parcel of land, and it's described in a certain way to person Y. And that deed is recorded or filed in the Registry of Deeds in a certain book and page number. And so that's how you keep track of who owns the title, and then you look and see if that person who owns that land gives another deed to someone else, and that's in the book and page, and you can track that along the way. The problem with that led to the creation of registered land was that there was no one checking those deeds to make sure they're accurate, that they really describe the land accurately, or that this person really did own all the land that they're conveying. And that can create a lot of problems that still come to my court. So the idea of registered land was to set up a system where a person could say, I want to get a judgment, a judicial decree from a court saying that this parcel of land I really own. I own it, nobody else owns it. And moreover, here's the boundaries of the land. Here's a plan that shows the boundaries, and it's been surveyed, and this is exactly where the land is. These are the exact boundaries, and I'm the only one who owns it. And that's all set down in a decree issued by my court, and no one can challenge that once it's issued. And in fact, we have an actual survey done of the land, and it's shown on a plan that's prepared with the dimensions. And the surveyor actually goes out to the land itself and takes metal stakes, drives them into the ground at the corners of the property so that you can look at the plan, go out and find out exactly where on the ground that plan is and where those stakes are. So this was a way to ensure title to property that couldn't be challenged by someone saying, oh no, I owned it from beforehand.
And this way, the 2 ways to register land, as you mentioned.
Right, so we refer to it as recorded land, which is the traditional way with deeds recorded in the Registry of Deeds, and then registered land, which are the certificates of title issued by the land court.
And how far does a system go? How?
Well, for deeds, there's deeds going back to when Massachusetts Bay Colony was founded in the 1600s, and the Plymouth Bay Colony. So that you can track deeds for land in Massachusetts going back to the 1600s if you do it. Now, that's a lot of deeds. It's a lot of time. And over the course of centuries, mistakes can creep into the record.
Yes.
And when mistakes get discovered in the title, that's when people come to us in a lawsuit saying, here's a problem with the title, we need you to help us fix it.
And now with the registered land, that's as of you mentioned.
So registered land is one of the ways the title can be fixed, by getting a decree that says, we've looked into it, gave notice to everybody who might have an interest in this land. They had a chance to come in and challenge it. People do come in and challenge it from sometimes, even for registered land, and then we might have a trial. But at the end of the day, you get this judgment that says who owns it. Now, that can also happen without registered land. Even in a case for recorded land, we can have a trial, and I'll end up with a judgment declaring who owns the land.
And what is the purpose of registering the land?
It's a way to get good title that can't be challenged by people saying, I have a prior interest in it. And then going forward, when you sell the land, you get a new certificate of title issued. And if you give a mortgage, that mortgage is put on the memorandum of encumbrances, which is kept as part of the record, and only encumbrances that are on that memorandum can be held against the land.
Yes.
Now, some of your viewers may have heard of adverse possession,
Yes.
which is an idea if someone uses land they don't own, but just uses it as if they owned it openly and notoriously and continuously for 20 years without permission, they can get title to that property. They come into court and get title for it. You can't get adverse possession on registered land. You cannot get adverse possession for that. So that's one of the benefits of registered land.
And notice, both the systems give notice.
Yes. And
very important benefit.
that's a very important aspect of land titles. There's a reason it has to be in writing, and that the title has to be recorded either in the Registry of Deeds for recorded land or as part of the registration proceeding. Because once it's down there and in the registry, that gives notice to the whole world that you have this deed to this property or that you own it. So nobody can come in with a deed after that saying, but this fellow sold me this property. I didn't know anything about this. I didn't know you owned it. I'm going to kick you out. Well, no. There it is. It's in the registry. You could have found it. It's in an index. People do title searches all the time. By law, you had notice. Whether you actually knew it or not, once it's recorded, you have notice of it.
And we were talking about, prior to this, people selling outrageous pieces of landmarks to other people.
Well, I mean, that's one of the purposes of having deeds in writing and having them recorded so that, someone can't sell you the Brooklyn Bridge. I mean, you want to know that the person selling you this house actually owns the house and has, can sell it to you and is not some person who just made up their deed. We've had cases where people just made up deeds and recorded them and then try to say, I own this. And then someone else brings a lawsuit saying, no, you don't. And we have to have a lawsuit about it. So if someone says, I'm going to sell you this property, you can ask them, well, what's your deed? Show me your deed. Tell me where it's recorded in the registry of deeds, and you can go check and make sure. You can even go back and make sure that that deed came from someone else who owned the property, and you can go back in time as far as you want, or that you can find in the registry.
But as you so rightly pointed out, if it's registered land, you can't take it adversely, and you have notice.
That's right.
And
for registered land, you can go back to the original registration decree and know at that point in time, the court determined this person owned it. I don't have to look past that. I don't have to go back before that. There's the registration judgment. There it is. It says who owned it. It says what the boundaries were. I can rely on that.
Is that judicial decree infallible?
Infallible? Well, it can't be challenged. We're never infallible. But the part of the registration process is a very searching and time-consuming examination of the title to make sure determine who owns it, examination of survey of the property, notice to people. So it is a long process. So at the end of it, you can be pretty sure we've determined who has the title. I mean, one of the downsides, of course, is it does take a long time.
This is a really important process for the land court to do. What does the land court do also in other aspects of real estate and
all right, well,
deeds?
Our jurisdiction is set forth in Chapter 185 of the General Laws, in Section 1. And there's a whole list, A through M or N at this point, of different areas we have jurisdiction over. So generally, you have jurisdiction over any case involving a claim of right or title in real estate or interest in real estate. We have claims for beach rights. We have claims that I own a property and you don't, claims of adverse possession, claims of whether there's an easement over the property. We also have jurisdiction over challenges to zoning, except oddly, not Boston zoning. So Boston zoning challenges go to the Superior Court, because Boston zoning is covered by a special act of the legislature. But for the other 350 cities and towns of the Commonwealth, who have planning boards and zoning boards of appeals, challenges to their decisions can be made in the land court or in the Superior Court. And we get a lot of zoning cases.
Do you have direct jurisdiction of specific or sole jurisdiction of specific areas?
We do. We have sole jurisdiction over cases involving registered land, as we discussed. We have sole jurisdiction to determine town boundaries. If there's a dispute between towns over their boundaries, we have jurisdiction over that. I haven't had a case like that yet. We'll see. We have sole jurisdiction over cases. There's a particular part of Massachusetts law that allows any landowner to bring a case in the land court to determine how a particular zoning bylaw or provision applies to their land, whether or not there's an application for a special permit or any kind of zoning relief. If you just want to know whether, say, I can build an office building on this property under zoning, you can bring a case for the land court to determine whether you can or not, or whether this zoning provision is valid or any application of the zoning.
That's really interesting, Your Honor. Where does the land court sit?
We sit in Boston. That's our main, and we have jurisdiction over the entire state. So most of our hearings and cases are done in Boston. I do try to do phone hearings for people who have to travel. And when we do have a trial for involving land outside, say, the 495 belt, often we judges will travel out to a courthouse near where the land is, so we can take a view of the land, see what it's like, and so that the witnesses who might all be out there don't have to schlep into Boston.
And tell us about the land court way to bring about cases. There's no juries.
So we are a court of equity. We don't have juries, so everything's done in front of a judge, whether it's a motion or a trial. The trials are bench trials done in front of the judge. So when I do a trial, I'm listening to the testimony. I'm the one deciding which testimony I credit and which testimony I don't, and who reads all the exhibits and papers, and then has to go back and decide what actually happened and what the outcome would be. And to do that, I have to write a decision. So I spent a lot of time writing decisions, either after trials or for motions for summary judgment, which are decisions deciding a case without a trial, because parties say, well, we know what the facts are, it's just a question of what the law is. But for all of those, I have to write a decision.
And where are your decisions published?
There's actually a publication called the Land Court Reporter that collects them and publishes them. And that's something that's read by real estate lawyers all over Massachusetts. And it's part of, these decisions become part of the common law of real estate in Massachusetts. The common law, it's a term inherited from England where we have most of our laws, especially in real estate and lots of other areas of the law that we inherited from England. Those were developed by judges deciding cases and then their decisions being published. And based on that, you extract the principles of law. And that continues to this day. There's statutes, but there's also judicial decisions interpreting the statutes and interpreting areas of real estate law that aren't in statutes. And our court's part of that.
Today we have Honorable Robert Foster. He is a justice of the Land Court, and we are learning about, Your Honor, how are these cases being brought to Land Court?
So people bring a case by filing a complaint like they might file in any other court. We follow the same rules of civil procedure as all the other trial courts. But you bring a complaint, the case is assigned to one of the judges. There's 7 judges in the Land Court. Once a judge gets a case, he or she keeps that case for the whole time. We don't rotate around. So we have a chance to sit with a case and learn about it and be with it and really get to know it. So one of the first things we always do is have a case management conference or a hearing at the beginning of the case where the lawyers, or if the parties don't have lawyers, the parties themselves come in and we talk about what the case is about, whether there's a chance the parties might reach an agreement and how we might help you reach an agreement. And we talk about the schedule for the case. Do you need to take discovery? What kind of information you want to share? How long is that going to take? Or maybe you have a chance to talk among yourselves and we'll come back in 30 or 60 days and talk about the case some more and see where you are. And then often I'll have meetings or conferences over the course of the case to check in where the parties are. Then if we get to the point where they want it decided, we say, okay, are we going to do it by a summary judgment? Does everyone agree on the facts? Or do we have to have a trial? And we schedule that, have a trial. Then I go off and think about it, write the decision, and mail it.
Your Honor, you must come across people who are unrepresented litigants.
We do.
And how do they go about their cases? And since they seem to be comes from the 1800s.
I think our court in particular, it's very hard for unrepresented people to do a case about real estate. It's a very specialized area. I think, Lucy, as you remember from law school, property law wasn't easy and it wasn't obvious. And there was lots of very odd concepts in there. So it can be very hard for people who don't have a lawyer to navigate the court and the case. And that's leaving aside the rules of procedure that they have to follow that they also don't know. So how do people manage? Well, we certainly try to give as much information about our procedures and our rules as possible. There's information on our website. But we also try to steer people to opportunities where they can get lawyers, either through legal services organizations, private lawyers, bar associations that might have pro bono attorneys. And we also have a program called Limited Assistance Representation, or LAR. And what that is normally when, under our rules of civil procedure, when a lawyer appears for someone in a case, they're in the case until the end. They can't get out without permission of the court.
Yes.
But they're representing that person from beginning to end. Now, for most lawyers, if they're going to do that and stay in the case through trial, they often ask their client to give them a retainer, a lot of money up front, because it's a big commitment. Well, LAR allows a lawyer to appear in a case just for one small part of it and then withdraw without needing permission of the court. And the idea of that is that gives people who might not be able to afford a lawyer for the entire case at least the chance to meet with the lawyer and get the lawyer to represent them for a part of the case. And it might be a very important part of the case. It might be this case management conference at the beginning that I told you about, where the lawyer can discuss with their clients what the case is about and tell me what the case is about, and maybe talk about with their clients how they might settle it. It might be just to help them with a mediation. It might be just for one of these motions that we talked about, a summary judgment motion, and help write the briefs and argue it.
Right.
And then if I allow it, great, and they've won and they can get out. If I deny it and say go to trial, and the lawyer's not obligated to stay in for the trial. And the reason that's important for these clients is that the lawyers will charge less to be in for part of a case, knowing they can get out, than they might be for the entire case. And that lets people, who aren't necessarily poor but can't afford a lawyer for the whole case, to be able to get a lawyer for part of the case.
Yes, and how do these unrepresented litigants, also known as pro se litigants, how do they find this limited assistant representation lawyers?
There's a couple of the bar associations keep lists of lawyers who are qualified, LAR qualified.
Okay.
The Boston Bar Association, the Real Estate Bar Association of Massachusetts, and the Massachusetts Bar Association. It's pretty easy for lawyers, and even if they contact a lawyer who says, I'm not on that list or I'm not qualified to be an LAR attorney, it's actually not hard for a lawyer to become qualified as an LAR attorney in the land court. All they have to do is, there's a training manual that's on our website and on the website for the Massachusetts Trial Court. And if you go to the link on our website for LAR, the trial court link for LAR, you'll find the manual. The lawyer can review the manual, and then they self-certify. They certify to us that they've reviewed the manual, they're qualified, and now they can be an LAR attorney.
Very good. How do people get in touch with the court and find it, the land court? What?
Well, we're on the web, so if you search for the land court, we're under the Mass Courts. I forget what the website is. I should have prepared this for this part.
You can Google land court, or is it
Google land court or Massachusetts trial court.
Yeah.
And there's a website for the trial court that has links to all the specific trial courts, and you can find information there. And it's a very good. There's a lot of information there, not just about LAR, but about the court, about our forms are on there, our rules are on there. You can also look for the trial court law libraries, which also have lots of information. So there is information out there if you want to find it.
Very good, Your Honor. Thank you. Tell us quickly about Massachusetts and the title or the deeds that are typically practiced in Massachusetts.
Well, as we talked about, there's a law in Massachusetts, in fact, throughout the United States and in all countries in the English-speaking countries, called the Statute of Frauds, which says you can't convey land orally. It has to be in writing. So that writing is in the form of a deed.
Yes.
And for those of your viewers who own their houses, they probably remember getting a deed when they bought their house. And it says, I, so-and-so, you convey to so-and-so the property described this way. And it's commonly called a quitclaim deed.
Yes.
Because it doesn't guarantee that I actually own the property that I'm conveying. That's why you do the title search. It's one of the reasons registered land was put in place. And so that deed conveys title, or you can get a certificate of title and a deed for registered land as well, and put that in the registration system. Now I know one of the ways people confirm that they're getting good title from the person giving them the deed is to get title insurance from a title insurance company. And the title insurance company does a title search and confirms that the person has title, and then they'll write a title insurance policy saying, yes, we'll ensure that you have this title. If it turns out we were wrong, we'll pay for the house, or we'll bring a lawsuit to try to clear the title, to fix it. And in fact, a lot of our cases are brought by lawyers who are engaged by title insurance companies on behalf of the owners to fix the title.
Thank you, Your Honor. Unfortunately, we ran out of time.
Oh.
But I want to thank our viewers for watching another episode of Discovering the Law. This episode can be viewed at www.discoveringthelaw.com. Today we have Honorable Robert Foster with us from the Land Court. My name is Lucy Rivera. Thank you so much for watching today.